All right, we're all ready?
Ready.
Okay. Good afternoon. Mr. Norris, Ms. Stroud, how are y'all?
I'm very well,
Doing great.
Good. Your Honor. Thank you very much.
Good, good. Well, we are live streaming and we're about to call court. Are y'all ready?
I'm ready to go. I'm excited about this new process and hopeful that my computer doesn't crash or freeze, but if it does.
If it does, we'll stop and then we'll address those issues and start up again. How's that?
That's good. I've been successful when that happens about logging in back pretty quickly.
Okay, terrific. Thank you. Rose, can you call court for us, please?
Court of Appeals for the 8th District of Texas is now in session.
All right, and at this time, I will call case number 08-19-00298-CR, which is Moses Jack Pop versus the state of Texas. And Mr. Norris, you may proceed.
Thank you very much, Chief Justice Rodriguez. May it please the court, my name is Robin Norris. I represent Moses Jack Pop, who was convicted of capital murder and sentenced to life with the possibility of parole because he was under the age of 18 at the time of the commission of the offense for which he was convicted. I have brought to the court 7 points of error. Because of time constraints, I'm going to emphasize some more than others, but I'm pleased to engage with the court on any which are of particular interest to you. And I urge you, I know you will, to interrupt me at any point with questions about any one of the points of error, no matter which order they occur in. Let me begin with the first 2 issues, which of course are the most controversial, and I really have elected not to spend too much time on them unless there are certain questions of interest to the court. This involves a pretrial motion to quash the indictment based upon failure to allege certain critical theories of culpability upon which we suspected the state would rely. This issue is an old issue, and I tried in my brief as succinctly as I could to develop a history based upon the Penal Code of 1974, which created what people call the parties theory of culpability, actually a theory of vicarious culpability in which a person can be convicted of an offense that he did not commit by his own conduct, but where he was responsible for the conduct of another. That section of the Penal Code contains particular conduct elements which are never alleged, or at least have been very uncommonly alleged since 1974 in indictments. I have a complaint that they did not provide adequate notice for that reason. The case was initially controlled, I think, as early as 1975 by Pitts versus State. I have tried to illustrate in my brief how contemporaneous issues involving similar questions of law were resolved differently. I've tried to frame for the court the issue that Pitts is contrary to the normal way in which such issues are resolved. And I just want to emphasize the importance of having the court specifically address the argument I make, which I do not believe has been addressed before by the courts of appeals, certainly not by the Court of Criminal Appeals. And that is that Pitts is contrary to other cases. The example I give and rely upon most as an analog is Jeter, which has to do with the allegations of elements in theft cases where lack of consent is based upon deception. But there are multiple other examples. I just want to insist and hope that the court will confront directly my argument that Pitts is in conflict with these other cases and that it should be resolved in my favor, but if it isn't, to have an explanation from the court why it isn't. let me move on then to issues number 4 and 5. These have to do with a complaint, first about the admissibility of, but particularly with the failure of the court to provide a limiting instruction at the time evidence of an extraneous offense was admitted into evidence over objection. This again is something that is almost a no-brainer to me. The law has been pretty clear almost time out of mind, certainly for decades now, that when particularly defense attorney has an objection to the admissibility of an extraneous offense and that evidence is admitted over objection, that it must be received for a purpose, of course, other than character conformity, which means that it must be limited in the jury's consideration, and it should be limited not only to exclude consideration for character conformity, but also to identify the particular purpose for which it's being received. I made a request for that. In this case, it was denied. And so that was an error. And it would be an error, but for one single exception, and that is for what's called same transaction contextual evidence. I actually have a problem with the law that allows admission without limitation for that kind of evidence, because the rules of evidence, excuse me, never allow consideration of extraneous matters for character conformity, even when they're same transaction contextual evidence. So some limiting instruction, in my view, ought to be required even when to exclude consideration for character conformity, even under those circumstances. But here, it seems fairly clear to me that this doesn't qualify as same transaction contextual evidence, excuse me, anyway, because it was not so connected with the offense being prosecuted that the jury would not, excuse me, be able to understand it without proof of the extraneous offense as well. The state has argued that it is same transaction contextual evidence. We disagree, and I think the disagreement is based upon real clarity in the record that it was not connected. Certainly, the state would have prosecuted Mr. Pop even without the extraneous offense. They would have sought a conviction and would have believed they were entitled to it, and they most likely would have obtained it. So the connection.
Excuse me, counsel, wasn't it kind of like within the same 24-hour period, or maybe even narrower than that? And it both kind of involved going to buy drugs, but really to steal drugs. It just seems like it kind of does fit, you know, a pattern or a plan, or kind of the same transaction.
I do agree with everything you said, Justice Halley. And what I would point out about that is that the fact that it was near in time and the fact that it was arguably a similar kind of offense does not make it same transaction contextual evidence. It was a separate offense committed arguably near in time, but involving different alleged victims, a different transaction, and the two transactions were not connected. Now, to the extent that it might actually have been admissible for the reasons you identify, which are the similarity in the details of the offense, perhaps offered for the purpose of proving one or more of the elements of the charged offense, such as that the charged offense involved a robbery, offering the extraneous offense, which was arguably another robbery, to prove that there actually was a robbery, or to prove Mr. Pop's role in this. All of those are potentially reasons why it might be admissible under Rule 404B. But evidence which is admissible under Rule 404B is always subject to a limitation, a limiting instruction. The fact that it is admissible for the reasons you give, such as a plan or a scheme of one kind or another, doesn't obviate the need for a limiting instruction.
Why doesn't the limited instruction that was in the jury charge suffice? Can you?
Well, first of all, the limiting instruction that was in the jury charge came too late. Defense counsel, in my position, was required by the law to request the limiting instruction at the time that the evidence was received. Had I not requested it at that time, I wouldn't have even been entitled to have it in the jury charge. I would have forfeited the right, and the jury would have been authorized under settled case law to consider it even for character conformity, absent an instruction at the time it was received. Court of Criminal Appeals has explained on multiple occasions that if you don't get it at that time, the jury is likely to consider it throughout the remainder of the trial for all purposes, as they are entitled to do, absent a limiting instruction, and that would essentially wipe out your entitlement to it altogether. There are other reasons why the one that was actually given was not sufficient, and I've also complained about that, and that's because the limiting instruction was not limiting. It essentially listed in boilerplate fashion every one of the potential purposes under Rule 404B for which evidence might be received, and did not limit it to the purposes for which it was offered. Indeed, the prosecuting attorney did not and refused on multiple occasions to identify the reason she was offering it. I don't think she had any idea why she was offering it. I think she was offering it to impugn Mr. Pop's character, basically. If she had had another reason, I would have expected her, particularly after multiple requests, to have identified that reason. In any case, evidence that comes in under Rule 404B, as opposed to specifically same transaction contextual evidence, is always subject at least to an instruction at the time it's received that it is not to be considered for character conformity or limited in such a way that it's clear to the jury it may not be considered for that purpose. So, and it was unquestionably an error not to give it, unless arguably it qualified as same transaction contextual evidence. So I want to move, if I can, to the last 2 points of error. These involve defensive evidence that was excluded. So in order to really explain the importance of this evidence, I guess I have to reiterate, which I tried to describe clearly in my briefing, what the defensive challenges were in this case and what kind of strategic decisions I had to make in order to try to meet or rebut the state's case, both on the issue of Mr. Pop's primary culpability, in other words, the allegation that he himself had actually fired the shot that killed the victim, and what we were not clear would be the theories of vicarious culpability upon which the state would rely. It became my defensive strategy after the trial began, and I had a feeling that it would be, that the best way to represent Mr. Pop was to try to show that he was not the one who actually fired the lethal shot, to try to convince the jury of that, and then to address the question of the two theories of vicarious culpability that were upon which the state was going to rely and which we came to realize eventually would be requested in the jury charge. One of them was what we call, I suppose, in a shorthand way, a conspiracy parties charge. That is that Mr. Pop was responsible for what Mr. Soriano did because they were engaged together in a transaction in which he should have anticipated that somebody would be killed. And if he wasn't the one who killed them, then the absence of evidence or persuasive evidence to show that he should have anticipated that, which is a pretty odd statutory element. If we could create some doubt of that, that would potentially result in an acquittal or a conviction of a lesser included offense. The other vicarious culpability theory upon which the case was submitted was the what's broadly called the assistance theory, that acting with intent to promote or assist the commission of the offense, he encouraged, solicited, directed Soriano to commit the murder. And And that was also something about which there was really no evidence in the case. In fact, it's my position that there was no evidence of that or of a conspiracy. And for that reason, we objected to having those issues submitted to the jury for consideration anyway, just based on the absence of evidence as well as on the absence of pleading. So in that sense, as a part of the evidence we intended to show that, we wanted to show the jury that Mr. Soriano had already pled guilty to, confessed to, and been convicted of killing the deceased in this case. And we offered that evidence through the plea papers, the judgment, and the judicial confession of Mr. Soriano. That evidence was excluded, and it was excluded upon the basis of an objection from the state that it was not relevant, which I don't think much more comment needs to be made about that. If the state's theory is that Mr. Soriano is the one who killed the deceased in this case, and that Mr. Pop is responsible for what Mr. Soriano did, it can hardly be irrelevant to prove that Mr. Soriano did. So by any reckoning at all, it's not irrelevant. There was an objection that it was hearsay as well from the state. And of course, it is an exception to the hearsay rule. Well, there are two exceptions to the hearsay rule that apply. One is for what we call pen packets. The state commonly introduces those, and these materials consist of exactly the same thing. They're also public records, and they come pretty clearly under the public records exception. And they were sufficiently prepared so that they met the admissibility, the authentication requirement without the need for a witness to sponsor them. I also thought I should make it clear that the statements contained in the judicial confession of Mr. Soriano, which were included among the papers, would also qualify as a hearsay exception because they were a declaration against penal interest. And those in the criminal context require corroboration, but of course, the same corroboration as the same evidence as the state relied upon to convict Mr. Pop was also relevant to the question of Mr. Soriano's culpability. So if the evidence was sufficient to convict Mr. Pop, it was certainly sufficient to corroborate Mr. Soriano's judicial confession. The state has also argued that it would mislead the jury. I find these things to be just, I ought not to even have to respond to them. The state knows that Mr. Soriano is the one who actually shot the deceased in this case. He gave a written confession that the state excluded from evidence, most likely properly. It was consistent with the statement made by Mr. Pop to the police, which the state also excluded, and we couldn't introduce. It could only be introduced against him. Both of those statements were entirely consistent with one another. All of that evidence, had it come in, would have been clear that Mr. Soriano was the one who actually did the shooting. The idea that by trying to show Mr. Soriano's culpability in this case that we were misleading the jury is just bizarre. We were actually trying to enlighten them. Let me also finally speak, if I may, in my last few minutes here, to the issue number 7 in the case. This capital murder theory was based upon a theory that the killing occurred during the course of a robbery. That's what made it a capital murder. And the robbery theory that was alleged and for which the prosecution argued at trial was that Mr. Soriano and Mr. Pop killed the deceased in this case during the course of robbing him of cocaine. The state introduced evidence of text messages that were exchanged between the deceased and Mr. Pop during the short period of time between when they had arranged to do the cocaine transaction, the buy or sell of cocaine from the deceased to Mr. Pop, at the very same time that the deceased was texting with Mr. Pop arranging the sale of the cocaine. He was contemporaneously texting with his girlfriend about the transaction that was coming up. He was telling her You know, I've got contacted by I'm meeting up with some guys who want to buy some cocaine. And his girlfriend says to him, what, you don't deal cocaine? You don't have cocaine. And he says, no, I'm going to hook him up with some other guy. The relevancy of the evidence, of course, was that the deceased didn't have any cocaine on his person and that no cocaine was taken from him. And the other evidence in the case, coupled with those text messages, also is probative of the contention that they did not attempt to steal any cocaine from him, because the only witness to the shooting saw that they drove away immediately after the shots were fired. Now, none of this proves anything conclusively. In fact, the evidence really on both sides is fairly thin, but that's not a basis for excluding evidence, which is relevant and probative. And it was the best way we could make our defense in this case, in addition to defending against the claim that he was a party, that he was responsible for Mr. Soriano's conduct, to defend against the claim that there was a robbery going on. That evidence was excluded, even though it is clearly admissible under Rules of Evidence 106 and 107 for evidence which, in fairness, ought to be received to understand the other evidence that was going on. In other words, the text messages between Mr. Pop and the deceased, and the text messages on exactly the same subject that were contemporaneously going on with his girlfriend, and the rule of optional completeness, which authorizes the receipt into evidence not only of a complete single conversation, but also of other writings on the same subject. So looks like I timed that pretty well. And I will await any questions from the court or my opportunity for rebuttal.
All right, thank you. Ms. Strauss?
May it please the court, counsel, I'm going to go ahead and if the court, unless the court has questions on any of the other issues, I think that counsel pretty much covered all of them except for issue 3. So unless the court has questions on issue 3, I will probably not address that, since I have the other 6 grounds. I think on the first 2 issues, the law is pretty clear in that regard about, he's complaining about the trial court not granting the motion to dismiss the indictment because the state didn't allege the law of parties in the indictment. But I mean, your starting point is the code, and the penal code, section 701C, states that the state is not required to allege the law of parties in the indictment. And subsequently to that, Pitts, the Court of Criminal Appeals in Pitts, stated that when you have an offense where you're charging someone as a principal or party, they may be charged as a party without alleging the facts which make the defendant a party to the offense. Now, courts subsequent to that, including the Court of Criminal Appeals, has affirmed that holding. And I know that the appellant has argued that that's somehow inconsistent with the line of cases talking about constitutional statutory requirements for pretrial notice. But and I think in the reply brief said that we did not actually address that argument. But the argument is there is no inconsistency because the law is pretty clear. Because the law is clear, the cases that he has cited regarding the pretrial notice are just simply not applicable. And that would be the response to that argument. And if the legislature has clearly stated it and the Court of Criminal Appeals has decided that that is the interpretation, that is the law, no matter how much the appellant thinks that shouldn't be the law. And since the state wasn't required to plead the law of parties in the indictment, the trial court didn't err in denying the motion to dismiss the indictment on that basis. Now, we go ahead and also discuss that, even if for some reason we were required to plead the law of parties, the appellant, none of his substantial rights were prejudiced because he received adequate notice of what the theories of parties liability would be at the hearing on the pretrial motion to dismiss the indictment. And that occurred 8 months before jury selection, when the state was talking about, or was making the argument, well, we don't have to plead that in the indictment. We specifically, when telling the judge, you would just, the court, that they would just need to charge the jury on 2 of the parties' theories, we identified the aiding theory and the conspiracy theory. So we specifically identified those 2 at the hearing. So this is not a situation where they went into it blind, not knowing what the theories of parties' liability would be. You know, we also said that this was a common scheme, that the 2 defendants were out there robbing people that night, that should have also put them on notice of the 2 theories that we would be relying on if it was raised by the evidence. I think if you look at the record as a whole, it's apparent that defense counsel was more than prepared. They, even during the plea discussions right before, I think, jury selection, discussed the law of parties with the appellant, and defense counsel stated that they had already discussed the law of parties with the appellant, and the appellant acknowledged that that had actually happened. So I just don't think that the record as a whole shows any harm or lack of notice because, you know, we didn't plead the law of parties in the indictment. And, you know, I don't think that we should hold that, or that we should say that the trial court erred basically in following the law. Like I said, the law is very clear. The trial court followed the law, the state followed the law. Real quickly, issue 2 is just sort of based on that same premise, which is, you know, courts of this state, the law is pretty clear that that the court can go ahead and charge the jury on parties' liability, even if you know, none of that was pled in the indictment. So that would not have made the jury charge erroneous to go ahead and include parties' instructions in the charge. Now, with respect to the complaints about the extraneous offense limiting instructions, in the complaint in issue 4, the appellant complains about not getting the contemporaneous extraneous offense limiting instruction. We, of course, you know, made the argument that no instruction, and this applies to issue 4 and 5, no limiting instruction was required because the extraneous offense was same transaction contextual evidence. And the reason for that is when you look at the timeline for the 2 offenses, the robbery of the victim in the extraneous offense, which was Desiree Guerrero, that occurred at approximately 12:46 a.m. approximately. Then, according to the text messages, the defendant started texting the victim in this case at about 1:47 a.m. So you're looking at about an hour's difference in time. And then the murder occurred somewhere between 2:22 and 2:25 a.m. So you're looking at less than a 2-hour period in which these 2 offenses occurred. They are so close in time. They occurred consecutively. They are similar in their manner of execution, right down to how they set up the drug deal and the language that they used. And so the cases that we cited in the brief have to do with the same transaction contextual evidence in crime spree cases. And the premise there is that, you know, offenses that occur so close in time during a crime spree is usually part of the story. So the story here for the state is that on that night, these 2 defendants were going around setting up drug deals and robbing drug dealers. That was the scheme. It just so happens that the second victim was murdered. So we would argue, based on the cases that we cited, this is same transaction contextual evidence, in which case the trial court was not required to give a limiting instruction either contemporaneously or in the jury charge. Now, we went ahead and argued also that with respect to the request for contemporaneous limiting instruction, that it was not clear from the record whether or not the trial court ever made a blanket refusal to give a contemporaneous limiting instruction. I believe the court went ahead and asked, do you want an instruction before these two witnesses testify? And instead of just saying yes, I believe that defense counsel then went into explaining the procedure that sort of sounded like a fact and evidence specific procedure that raised concerns with the trial court and the state about the possibility of commenting on the weight of the evidence. Now, once the trial court said that it didn't want to, do it in such a piecemeal fashion, there was never a renewed request that, okay, well, I'll go ahead and take the just general instruction before these two witnesses testify. So I'm just not sure that the record is clear that there was an adverse ruling in the sense that the trial court decided that it was just not going to give any kind of instruction at all under these circumstances. But we also argue that, even if there was some error in that regard and it was preserved, that the record doesn't support a finding of harm because the jurors were expressly informed prior to deliberations that they were not to form an opinion about the case before they had heard everything. The trial court included a proper limiting instruction in the jury charge, and Guerrero, which was the victim in the extraneous offense, was not listed as a victim in this case, thus lessening the risk that the jury in some way thought that he was he was being charged with that as well for this offense. The evidence was sufficient to prove his guilt. And during the time that passed between the testimony of the two witnesses on the extraneous offense and the reading of the limiting instruction, the state never relied on that evidence for any improper purpose. I think if you look at the closing arguments, especially, appellant's closing argument, the defense counsel actually told the jury, look, the defendant is entitled to be tried for this offense only. And they said that we put on the extraneous offense just to make him look bad, but that the only offense that he was being charged with was the murder in this case. Additionally, we mentioned the extraneous offense, but we made it clear, and I disagree with the appellate counsel, that the state never identified the purposes for which we were relying on that evidence. We specifically said at various points in time that we were relying on that evidence for purposes of identity, intent, motive, opportunity, knowledge, and rebuttal of a defensive theory. And that's basically what we argued during the closing arguments. And also, those are permissible purposes under Rule 404B. There's no evidence at all that the jury formed an opinion about any of this before deliberating. And so for those reasons, we would argue that any decision not to give the contemporaneous limiting instruction was harmless. Now, with respect to the instruction in the charge and the complaint that it wasn't the limiting instruction in the charge and that it was not sufficiently limited to the 404B purposes for which the evidence was offered, I cited a handful of cases in the brief that hold that it is not error to include potentially non-applicable 404B purposes, so long as the ones that were actually included in the charge are supported by the evidence. And there are a number of these that are in fact supported by the evidence. And those cases hold that anything that doesn't really apply can be disregarded as surplusage and just disregarded by the jury as not being applicable. Here, like I said, the purposes that were listed, as far as identity, motive, intent, opportunity, knowledge, those were supported by the record. And that's why this case is distinguishable from Daggett, which I think is what the appellant relied upon, because in Daggett, the court was, or the jury was charged with a 404B purpose that was not supported by the evidence. And the one purpose that could have been supported by the evidence was completely excluded from the jury charge. That's just not the situation that we have here. And we would just argue that for the same reasons, any error in that regard is harmless. It's just surplusage. It doesn't apply. The importance of the limiting instruction is just that the jury does not consider the evidence as substantive evidence of guilt. And whether or not you put in additional purposes in there, the instruction still tells the jury, you are not to consider this evidence for anything. You can only consider it for these purposes, and that is it. That implicitly tells the jury that they may not rely on that evidence as substantive evidence of guilt. So the appellant's sixth issue, having to do with the disposition of the co-defendant's case. I cited a number of cases that hold that this type of evidence is completely irrelevant and inadmissible as far as proving up the guilt of the defendant in the instant offense. I mean, no more than we could put on evidence of the disposition and say, see, he pled guilty, so this guy is guilty. We wouldn't be allowed to do that. And it's just irrelevant. And there's a number of cases that I cited in the brief for that proposition. It's not relevant because it doesn't make his guilt more or less probable in his trial. Now, the other issue with this that we also argued was a potential 403 issue, which is the stated intent for this evidence was to argue to the jury that by pleading guilty, somehow that these documents, the indictment, judgment, and plea papers, would show that the co-defendant had accepted responsibility as the principal actor and the shooter. And there is literally nothing in those records that demonstrates that. Even though the indictment alleged principal liability, as was already discussed in the first issue, he can go ahead and plead guilty as a principal or a party because the indictment authorizes it. And so the problem that we saw in this instance was how they intended to use the evidence to argue to the jury that this was somehow evidence that the co-defendant had accepted responsibility as the shooter. That had not only was that not demonstrated by the evidence, it had a significant risk of misleading the jury into thinking that because the co-defendant had pled guilty, he must have been the shooter. And so for those reasons, we would also argue that the trial court did not err in excluding that. But even still, assuming that the trial court somehow erred in excluding that evidence, it's harmless error. And the reason for that is the exclusion of that evidence did not prevent the appellant from presenting his defensive theory that the co-defendant was the shooter, and the appellant had no idea what was going on. He was still allowed to pursue that defensive theory. He cross-examined our witnesses to that effect. He presented witness testimony to show that the appellant didn't need to rob anybody, and that he had been angry at the co-defendant after the murder. So he was able to pursue his defensive theory and pointing the finger at the co-defendant without evidence of the disposition of the co-defendant's case. Now, with respect to the final issue about the text messages between the girlfriend of the victim and the victim at about the same time as the drug transaction in this case, we first point out the fact that if you actually look at the messages, it doesn't quite say what the appellant wanted to represent the messages as stating. If you actually look at the conversation, the text conversation, the victim never says that he does not have cocaine on his person. He just says when the girlfriend asks him, "Are you going to sell it?" or she just says, "You sell," and he says, "Nah." And then there's nothing here that says that he was going to send the appellant to somebody else to go ahead and complete this transaction, because when the girlfriend asked, well, the victim's response is, "I'm take him to the spot, my friend got it." And I'm paraphrasing there, but that I don't know. I think it's within the zone of reasonable disagreement for the trial court to believe that it wouldn't have been a reasonable inference for the jury to draw those conclusions from this conversation, and that for that reason it would not be admissible under the rule of optional completeness. The other issue that we raised was under Rule 403, aside from being misleading as to fact, it's also misleading as to the law, because we put on the text messages between the victim and the appellant to show the appellant's intent in going to this transaction thinking that the victim had cocaine to sell. Now, we don't have to show a completed theft in order to prove the robbery for the capital murder. All we needed to show was that the defendant believed it, and whether or not the victim told somebody else, that he wasn't going to sell the cocaine or he didn't have the cocaine. If the defendant is not privy to that, that does not add context to that conversation and have the potential to mislead the jury. And so if the court has no questions, I'm running out of time, the state would ask that the appellant's conviction be affirmed.
Thank you. Mr. Norris, rebuttal?
Yes, thank you very much. Let me go through some of these things as quickly as I can. As to the contention that there is no internal conflict in the law at all between Pitts and cases such as Jeter and a wealth of others, the general rule in Texas, to put it succinctly, is that the indictment must allege all conduct and culpability elements upon which the state will rely to convict, even if those elements are outside of the main definition of the offense, such as in statutory definitions. I listed the theft statute as being a good example of that, and showed how the court had originally in Thomas held similar to Pitts, but then retreated from that later in Jeter. Again, the general rule is that all conduct elements must be alleged if they're going to be relied upon by the state, even if they're outside the main statutory definition. Conduct elements, acts or omissions, and culpable mental states. That conflicts with Pitts. It rather clearly conflicts with Pitts. Pitts is the only example I know of where the court has not applied that rule. And for some reason, the conflict has not been addressed. I just ask the court to acknowledge the conflict if the court finds that it exists, and to resolve it one way or another, so that the issue will be squarely presented.
Mr. Norris, are you challenging the constitutionality of section 7.01 or 7.02?
No.
Okay. And why is that?
I don't believe that it is unconstitutional for a state to criminalize conduct. I mean, I don't believe that it is unconstitutional to make someone responsible for the conduct of another if he engages in conduct himself, which can be criminalized. It was previously criminalized as an accessory. But Chapter 7 provides clearly, acting with intent to promote or assist the commission of the offense, he aids, encourages, solicits, directs. Those are conduct elements and culpability elements. That is what it must be proven that he did in order for him to be found guilty of murder under the theory, not that he committed the murder himself, but that he is responsible for that of somebody else. I don't believe those elements are unconstitutional. I just think the Constitution requires that the state tell him that that's what they intend to convict him of.
And so if you were surprised by the state relying on section 7.02A2 and 7.02B at trial, why didn't you move for a continuance in order to prepare a defense?
Well, first of all, let me tell you, I was not entirely surprised by it. In fact, if the court reads my motion to quash the indictment, I acknowledge straight up in the motion that I suspect that's what they're going to do. I don't know which of the four available vicarious culpability theories they're going to rely on, but also part of the reason for having this notice come in the indictment is that it commits the state to prove those things. You know, in other words, an indictment is not simply a way of providing notice. It is a way of providing officially the basis for the prosecution, and they're going to be committed to it. Now, I did include in my brief a short section where the Court of Criminal Appeals has suggested that the notice can be provided outside the indictment. I think that's very unorthodox and probably conflicts with most of Texas statutory law and the Code of Criminal Procedure. But putting that to the side for the moment, the Court of Criminal Appeals has indicated that the notice may be provided in discovery, but they have clearly telegraphed that it's going to have to be on the record, probably in writing, and that once they identify the theory that they're going to prosecute, that they're going to be committed to it in the trial, same way as they would any theory alleged in the indictment. So, yeah, I wasn't totally surprised, but I wasn't sure exactly where they were going with it. And I told them straight up in the motion to quash, look, if you want to rely on this, I want you to plead it. That's the way our law works.
And so you're asserting that the notice is not enough, that it has to be in the indictment.
Yes, and the notice has to be official, and it has to be precise, and they have to tell me which of the parties' theories they're relying on. And they have to tell.
So where do we get the authority to do that?
To do what? To hold that that's true?
Right.
Read Jeter. Jeter is an analog. It doesn't talk about parties, but it does talk about alleging the elements of theft by deception. Those elements appear in a definition, not in the main statutory theft offense. And the Court of Criminal Appeals originally held, similar to Pitts, that they didn't have to be alleged in the indictment. But then after 9 years of that, they retreated from it in Jeter and said, no, because these are conduct elements, they have to be alleged, particularly when a motion to quash has been filed. And so that would apply equally in the parties context, the vicarious culpability context, except for the court has never really addressed it there. But there have been, as I cite in my brief, various places where there have been dissents, and most recently in Maribel, which is the case most often cited. It's quite old now even, but it was in the 2000s, where Judge Womack particularly wrote a dissenting opinion saying, well, wait a minute, I think we took a wrong turn on this. Judge Miller has also done the same thing in some of his opinions, and Judge Clinton, even the author of Pitts, expressed some reservations about it later.
But you would agree with me that, and I think you've stated that, is that it's not currently required by statute or case law.
The rule that conduct elements outside the statutory offense.
You're saying that the conduct, but there is no rule that a principal, if you're being charged, as in this case with capital murder, that the indictment does not have to allege whether you committed capital murder either as a principal or as a party or accessory. There is no statute or case law on that explicitly.
Pitts explicitly holds that you don't plead that. Right?
Okay.
And that's been reaffirmed at least as recently as Maribel by the Court of Criminal Appeals. And of course, it comes up occasionally in the intermediate appellate courts as well.
So, and I mean, as you're well aware, we have to follow the precedents of those cases.
Right. And to be frank about it, I rather suspect that you will find after examining it that you're not free to abandon the holding of Pitts, that you find it still to be controlling, and that I would lose that point of error. All I want is for you to honestly take a look at the cases I've cited, to come to a conclusion whether, as I claim, they are inconsistent with the general rule as expressed in Jeter and other cases, and to just state why you feel you have to resolve it contrary to that, or not to apply that line of cases because, for example, Pitts is more specific to the parties context. I just want my argument finally to be addressed.
I understand. And in regards to the other alleged errors, assuming we were to find them in error, then your argument would be that it is that the defendant Mr. Potts was harmed to such a degree that we also have the authority to reverse it.
Well, yes, I do. And, you know, so much of the state's reply has had to do with issues of harmfulness. And I tried to address that in my brief as much as I could and in my reply brief. But the point is that with respect to each of these, they significantly affected my ability to actually prepare an effective defense. It wasn't that I couldn't make an argument to the jury. I mean, as I've said in my brief, one does the best one can, but I'm entitled to put on evidence which is admissible to help me prove my case. It doesn't have to be conclusive, it just has to be relevant. And when you do that, you know, any significant amount of harm that would compromise your ability to effectively make your case is a sufficient amount of harm, particularly in the aggregate. And I would insist that harm is to be evaluated in the aggregate. In other words, you know, if there
I
are
understand.
yes, I don't have to repeat that. I know the court understands that, but I thought it was important to emphasize it under the circumstances. These things all operated together to inhibit me presenting a complete defense for Mr. Pop.
I understand.
Yeah. I have 28 seconds. I thought maybe there was something more. You know, I was going to say, particularly strikes me as odd when courts say, and they do, just as opposing counsel has said, that when you give a limiting instruction, if you throw in everything but the kitchen sink, it's okay if one of those things meets the criteria. I don't think if we're going to hold that we should any longer refer to it as a limiting instruction. You know, when it's not limited at all, it's kind of a misnomer. I could call it something else, perhaps, to call it a limiting instruction. You don't just throw the whole kitchen sink in with everything. Everybody thinks that in the parties context, not in the parties context, but in the extraneous offense context, the 404B context, that those things are what always should go into the jury charge. None of those have to go into the jury charge. Those are just examples. Something entirely outside of 404B could be the reason that this is relevant. And if it is, that's what the jury should be told.
All right. Thank you very much. Thank you, Mr. Norris, for your excellent argument. Ms. Stroud, we appreciate your participation in answering our questions today. Your case will be submitted on the brief and your presentation. So thank you again. I appreciate it.
Thank you. Thank you, judges, justices. I'm pleased to see you all well. May I be excused.